Sometime about a year ago, Local 46 came to my office and asked us to assist them in a project under which they would try to discover new weapons, new approaches to battling the problem of non-union construction firms taking business away from unionized workers and firms that were prepared to pay a decent wage and fair benefits for their members. The first thing we did, because we knew one of those firms had filed a Chapter 11 proceeding, a firm called HRH, which is a long and storied firm in the New York City construction industry, was to put together a coalition of unions, including Local 46, the Mason Tenders District Council, and Teamsters Local 282, into an ad hoc labor committee that would represent the interests of workers that had claims against HRH in the course of the bankruptcy proceeding. That is a tactic that I think is relatively new in the arsenal of labor, and we're pleased to have developed it. And it's been a very positive vehicle for our being able to discover details about the operations of the firms that are now defendants in the lawsuit that was filed this morning. Through a process in bankruptcy court entitled or called Rule 2004 Discovery, we were able to subpoena records about the projects that in the past the union had really only known on the street. There had been very substantial picketing at 350 West 37th Street, with the Gold Street project, and at 184 Kent Street. All projects that were being worked on in 2008 and 2009, a time when there's very little construction work in the city. These projects would have been very important to assisting thousands of union members in protecting their livelihood and the benefits that their families enjoy. Now, those projects were done, in our view, by HRH. HRH had a contract with the building construction trade unions that obligated them to employ union members and to make sure that their subcontractors employed union members. They knew that, but they adopted a fiction in performing their work on the projects I just mentioned, West 37th Street, Gold Street, and 184 Kent. A fiction in which they were not, in fact, the construction manager. The construction manager was an entity with which they claimed no relationship called Leviathan. And what I'll describe in a minute in that chart is the process through which HRH sought, through, we think, a series of frauds, serious fraud, to have the opportunity to perform this work, but to do it through a vehicle that did not have any obligation to employ union labor. Now, I will go through the complaint that we filed this morning, which is in the tab, that file that you guys got. But I thought I'd first go through as a general outline how we think this, what we've labeled the Singer criminal enterprise, performed its work, and how these various entities interrelate to one another. Obviously, a corporation is entitled to do business. It's entitled to do business with whom it wishes. It has no obligation to perform union labor unless it has a contract that requires it to do that. But it's possible for a corporation, and Congress recognized this decades ago when they passed the RICO Act in 1967, that it's possible for a legitimate enterprise to be so affected by criminal activity that what you have is a de facto criminal arrangement that in this case was run by the Singer family as well as some of their employees and some of their associates. Now, that Singer criminal enterprise had ownership and control over HRH. There was no doubt about that. They've always acknowledged that. What they denied is that they had similar ownership and control over Leviathan Construction. And we were able to establish through the discovery in the bankruptcy proceeding I mentioned earlier that Leviathan Construction was owned entirely by the wife of one of the Singer brothers who also owned HRH Construction. As the complaint alleges, the Leviathan was established on August 2nd, 2007. The ownership was completely in the hands of Susan Singer, the wife of Brad Singer, the president of HRH Construction. Now, a year later, I think in a further effort to cloak the relationship between the Singer family and Leviathan, a year later, they put the title to Leviathan in a different corporation called Avery Maya. Now, it didn't take a great deal of intelligence to realize, after some questioning, that Avery Maya is the name of the grandchild of the Singer family. It was started by the mother-in-law of Brad Singer, using an address in the Bronx that was intended, again, we think, to cloak the reality that the Singer criminal enterprise had ownership and control over Leviathan. And what we established in discovery is that HRH and Leviathan had common ownership, shared employees, they shared expenses, and there were money transfers between them of significant amounts of money. Now, the way they were able, they thought, to get around the union obligation to pay fair wages and benefits to its members is that HRH Construction acted as the so-called owner's representative. An owner's representative is an entity that has no responsibility for contracting or hiring individuals on a job site. So if they were only an owner's representative, then they would take the position that they had no obligations under their collective bargaining agreement. But they selected, if you can call it that, Leviathan as the construction manager for these projects. Now Leviathan was really the same thing as HRH, so HRH was really both owner's representative and construction manager, and as construction manager they had an obligation to abide by the union contracts, hire union members, and pay fair wages and benefits. Now they did this not on their own, but in conjunction with Leviathan developers on two of the biggest projects in the last 3 years in the city. The Townsend at 350 West 37th and Brooklyn Gold, 235 Gold Street. There is no doubt that Leviathan was well aware that Leviathan was a mere shell that was being operated by the owners of HRH in an effort to avoid the obligations of the union contract. Their willing participation in that fraud is what makes them participants in the Singer criminal enterprise and liable to the unions for the damages that have arisen as a result of their failure to respect the contracts. Similarly, JMH Development for 184 Kent was also supposedly retaining Leviathan as its construction manager and HRH as its owner's representative, but if you examine the details we put in our complaint that was filed this morning, you'll see there's an absolute recognition by JMH that the real party they're dealing with as their construction manager is HRH, and they're only putting it in the name of Leviathan Construction because it allegedly allowed them to avoid the breach of their union contracts. Now, Leviathan, of course, got millions of dollars as a result of the diversion to it of monies from these three projects. Where did that money go? That money went in payments to the Singers. It went in payments as management fees, it went in payments for pensions, and it went in payments for expenses of the Singers that were passed on to Leviathan, notwithstanding the argument they originally gave us that they had no relationship with Leviathan. Now, the fraudulent payments went from Leviathan to Leviathan, and from Leviathan to the Singers. Similarly, the fraudulent payments went from JMH to Leviathan and then up to the Singers. Now we have approached this matter not as a labor law violation, but as a criminal matter, because the course of dealings between the Singer criminal enterprise and Leviathan and JMH Development, in our view, represented instances and repeated instances of mail fraud, wire fraud, bankruptcy fraud, and fraud on the employee benefit plans that should have been recipient of contributions. And what happened as a practical matter, as Bob mentioned in his earlier statements, is that thousands and thousands of hours were worked on these projects for very little money, very little above minimum wage, with no health pensions, as Bob mentioned, no health coverage, no pension coverage, no vacation, no sick pay, no holiday pay, none of the typical benefits of a union contract. And the amount involved, we think, is many millions of dollars. We think it will be tripled as a result of the award of the damages under RICO. And we are confident that at the end of the day, this will stand as a message to the construction industry that if you are a legitimate company, if you have a union contract, you are obligated to follow it. If you take steps to avoid it by creating the kind of shell enterprise that Leviathan represents, that the unions will find it, they'll find you, and you're going to pay. So in our view, we recommend employers with union contracts abiding by them and working with the unions to try to create a better future for our members and to build safe, build well, and build with quality work in the